Okay, good afternoon, everyone. Thank you for joining us today for our second exciting session during our virtual North Country Telehealth Conference, which is our theme this year is Uniting the Future of Population Health and Virtual Care. My name is Katie Cook. I am the Telehealth Project Manager for Adirondack Health Institute. All of the sessions this week are brought to you by the North Country Telehealth Partnership, which is a joint effort since 2015 between AHI and Fort Drum Regional Health Planning Organization. You see our respective CEO and executive director on this slide and our logos. This afternoon's session is compliance with Part 2 regulations in telemedicine. And our speaker is Cassandra DeNova from Rivkin Radler. We do want to give a sincere thank you to all of our past sponsors. This is the 6th year of the North Country Telehealth Conference, and it would not have been possible without the organizations represented on this slide. We do hope that next year we can be in person, which would give you a chance to attend and see the exhibit hall where many of these vendors offer some really exciting and up-and-coming telehealth products. A few housekeeping items before we kick off today's session. You should be muted and your video should be off. To avoid audio issues, you will want to choose either your computer or phone audio. If you have both on, you may hear an echo. So you'll want to make sure only one of those is checked. For optimal viewing, we do recommend using side-by-side mode on Zoom, and to activate that, you would click on View Options at the top center of your screen and choose side-by-side mode from the drop-down. For Q&A today, we will be holding questions until the end of the session, but use the chat box to submit any questions, whether it's technical or for the speaker, and AHI staff will triage those, holding questions for the speaker until the end. And of course, all of our presentations will be archived on our website by October 9th, and we are recording today's session. I'm now going to introduce Cassandra. So let me just stop sharing. Perfect. So Cassandra is an associate attorney at Rivkin Radler LLP in the Health Services Practices Group. She provides transactional services to corporate health entities. And prior to joining Rivkin, she completed a 2-year clinical ethics fellowship at Albany Medical Center. So Cassandra, you can take it away.
Thank you very much. That was a very nice introduction. So hello everyone, and thank you for joining me this afternoon. I'm going to share my screen so you can see my presentation. Alrighty. All right, so I'm here today to talk about complying with the Part 2 regulations in telemedicine. So just to give a brief overview of what I'm going to be discussing today, I'm going to go through the Part 2 regulations. This is for those who want the legal site. This is 42 CFR Part 2. I will be referring to them as the Part 2 regulations. And so I will talk about their general requirements, who these apply to, and I would say some specific information relating to them. Then I'm going to go through some special considerations in complying with the Part 2 regulations while practicing telemedicine. This became, I would say, very apparent since we've been in the COVID pandemic, and so I'll kind of highlight some of the things that came to light during that time. And also I will discuss some of the recent changes that have come out in light of the COVID pandemic and some of the guidance out there. And I will conclude with some lessons learned and maybe some looking back on some practices that we can change moving forward. So the Part 2 regulations. So just some general requirements of what the Part 2 regulations are. They prohibit the disclosure of information that would identify a patient as having a substance abuse disorder without consent, and that's patient consent or a court order. The overall goal of these regulations is to protect patient information, and the overall goal is to encourage patient participation in substance abuse treatment. And so this is an added protection onto confidentiality regulations already out there and existing. And it's simply just because substance abuse treatment patients can actually have, I would say, discrimination, and this is to protect them from any possible ways that people would find out that they're seeking treatment. Again, overall goal, protect patients. There is very, very specific consent requirements when it comes to the Part 2 regulations. These are actually far more specific than the HIPAA regulations. For healthcare providers out there that I'm sure are very familiar with HIPAA, the standard HIPAA consent form actually does not comply with the Part 2 regulations. And one of the interesting requirements about it is you're actually required in the regulations to resist a compelled disclosure absent that consent or that court order. So if you just receive like a subpoena, that's not good enough. You need more than just that. Also, there's very specific contents that need to be in the court order itself. And so there has to be specific findings that the court has to make. And it's also supposed to give the patient an opportunity to object to the disclosure of information. And there's also a prohibition on the redisclosure. So for example, if a provider gets the information via the patient gave consent to send it to a certain provider, that provider is not supposed to share it with someone else. So who has to follow this? And this is, I think, the most key part when it comes to the Part 2 regulations. So it's what's called a Part 2 program, and this is a program that in whole or in part holds itself out as providing alcohol or a drug abuse diagnosis, treatment, or referral for treatment. So to sum it all up in non-lawyer language, it is a provider that's holding itself out as providing alcohol or substance abuse treatment. This excludes hospital emergency departments and general medical surgical wards. So this is a very narrow, I would say, provider group of who is considered a Part 2 program. And what information does it cover? It includes records, any information, whether recorded or not, created or received by a Part 2 program relating to a patient. That itself is very broad. And so this covers not only treatment information, but any information that's going to identify the patient as having a substance abuse disorder. And what's key to remember with that is a patient, if they're going to be at a program, the name of the program itself and the fact that the patient's there in and of itself could disclose the fact that they're receiving treatment. This also covers verbal information. So if you notice it says recorded or not. So when you're having when providers are having conversations about patients, it's something to keep in mind in terms of who's around and who's listening. And I won't read this big long definition, just simply because it's just what covers is substance abuse disorder records and information. So what are some differences with HIPAA? And I think this is very important, simply because this is far more restrictive than HIPAA. HIPAA has a lot of exceptions within it that actually allow for information to flow between healthcare providers and giving treatment. That's not the case when it comes to the Part 2 regulations. They're very specific, again, to substance abuse disorder records, as opposed to HIPAA is focusing on PHI, personal health information. I should say personal identifiable health information. Under HIPAA, there is I would say the broad overarching exception that covers majority of the information that's flowing between healthcare providers, and that is the health information is permitted for treatment, payment, and healthcare operations unless the patient opts out. The Part 2 regulations, as of right now, do not have that exception. However, the CARES Act, as I'm going to get into later on, actually added this exception in, and it won't go into effect until next year, but as of right now, we don't have this exception. So again, the Part 2 regulations require express written authorization. And they also provide special, I would say, additional protection for records and civil litigation proceedings. Again, as I mentioned earlier, it has to have a very special court order and also an opportunity for the patient to be heard. But what's so important about following these? What happens if you don't follow these regulations and improperly disclose information? Well, it's a criminal fine. And that is the exclusive remedy for violation of these regulations. Reports of the violations go to the United States Attorney and also the Substance Abuse and Mental Health Services Administration. That is the federal agency that's in charge of overseeing compliance with these regulations. They are also the overarching agency that has, I would say, very helpful guidance information. So if you're looking for any information or even looking for guidance on how to follow the regulations, they're a very good agency to look at. So the United States Attorney is the one that will prosecute these violations, which means that there is no private or right of action. And non-lawyer language, that means that a patient, him or herself, cannot sue for any sort of civil liability underneath these regulations. Now, if there is a violation, the patient may be able to sue other under causes of action, so you're not off the hook. But at least the patient can't sue for recovery under this regulation. It's only the United States Attorney General that would be criminally prosecuting you for violations. Now, going through, I would say, just some of the brief requirements for the consent forms. So under the regulations, the consent forms, they have to have the name of the patient, the name of the individuals or entities that the information is going to go to. One change that has happened recently is originally you always had to include the specific name of the person it was going to. So for example, if you signed a consent form to allow information going to the Department of Social Services, you had to have a name of a specific person from the Department of Social Services. For some providers who are very familiar with this, that itself may have caused a barrier, especially when you're dealing with agencies that have multiple people involved in the situation. That requirement about having a specific name for a person has been changed. And so now you can simply put an entity name and that will be allowed on the consent form now. You're supposed to include the amount and the kind of information being disclosed and the purpose of the disclosure. So as you can see, the consent form is supposed to tell you, who, what, why, and then also the duration of when. Consent forms, they're not supposed to be indefinite. They're supposed to give a standard time of how long they're going to be good for. And the duration could actually be an event itself. So for example, in a legal proceeding, you could say this consent is as good as long as this action is going on. One place that actually has some very nice templates that you can use and kind of compare to your own templates is the New York State OASIS has templates that are compliant with these regulations. And so that's one place that you can turn to for consent forms. All right. So there are only 6 exceptions, unlike the HIPAA regulations. These 6 exceptions are situations where you would not need consent or you would not need court order to disclose information. And I'm just going to click real quickly and get them all up here. And you can see that these are, I would say, very narrow exceptions. So you have Department of Veterans Affairs, the Armed Forces, communication between a Part 2 program and the entity that's doing administrative services or administrative control, qualified service organizations, and crimes against Part 2 on Part 2 premises and against Part 2 personnel. This exception, if you look at it, it doesn't cover any crimes that a patient may have committed that is not against the personnel and it's not on property. So for example, if you find out about a patient committing a crime off premise, you wouldn't be able to disclose that information without a court order or without patient consent. and also reports of suspected child abuse and neglect. There are also 3 situations that don't require consent. And the first one, medical emergencies, came to play when it came to COVID pandemic. And I will go into this one in far more detail because this is also, again, relevant for the COVID pandemic. And also it came up at least when you were providing telemedicine during the COVID pandemic. One of the other disclosures is research and audit and evaluation. And for audit and evaluation, there's the specific types of audits that you don't need to have the consent, which is Medicare and Medicaid. All right, now I'm going to turn to covering telemedicine and some special concerns with complying with these very strict regulations and practicing telemedicine itself. So to recap, these regulations themselves are very focused on patient confidentiality. And so when you're practicing telemedicine, your overall goal should be focusing on patient confidentiality, especially complying with these regulations themselves. So some specific concerns to think about in the ideal world, I would say you want to be open and communicate with your patients about your office practices when it comes to telemedicine. Having open communication and telling them how you're going to practice the telemedicine can also prevent any issues and any possibilities of having any violations and disclosing information to the wrong people. Keep in mind in practicing telemedicine, there is what's called metadata. So for example, when you log onto a computer, you can see an IP address attached to an email, or even if you're sending it from say like a cellular device and the location services are turned on, there is the locations attached depending on how you get that information from that email. So there's this hidden data that's inherently attached to text messages, emails, about where and what is sending the information. That information itself is also, you have to think about it in terms of, is there a way that we can protect that information? But also think about it, is this information, if it was improperly disclosed, is that going to identify the patient of having a substance abuse disorder? Also have to keep in mind whatever devices you're using, whether or not they're hackable. Some best practices to think about is having some sort of patient verification system. And this could be something that the provider does right when they sign on with the patient, or even if it's by email or whatever means that you're doing for your telehealth visit. You need some way to verify that the person on the other end is in fact your patient, and you're not giving the information to, say, some hacker who's just looking to gather that information to sell it. Also think about the reliability of the vendor you're using. So this is, and when I'm saying vendor, I'm thinking of if you're hiring a service to either protect your information, so if you're using any cloud-based services for storing information, or even any of the software services, but any sort of vendor you're using, you want to be able to look them up and see, have they been hacked in the past? For any of these, I would say, big breaches out there, you can Google the person or the entity and see if they're in the news. If they've had one of these big breaches, you're going to be able to find out about it very quickly. Also, keep in mind that you may or may not be using public internet. Also keep in mind that the patients themselves are likely going to be using public internet, depending on what access the patients have. And so this is more opportunities for this information to be improperly disclosed or hacked. What's more important, and I think a lot of providers sometimes don't think about, is think about the location of your confidential informations. Try to have a location where no one else who is not part of your program is listening to that conversation. It may be hard, at least in terms of while we've been in the COVID pandemic and you're working at home with, I would say, other family members. But other options include having one of those sound devices outside your door, so that way it can muffle what's been, so no one can hear. But also this is the same thing when it comes to patients. And so this is a conversation that as a provider, you may want to consider having with your patient in terms of they have to think about where they're having their visit with you. Do they have a quiet space in the house that they can go? Do they want to think about investing in one of these sound device or the sound noise machines that they can put outside their door so no one in their family can hear what's going on? Also think about the ability to obtain consent. So again, one of the main issues with the Part 2 regulations is you can't disclose the information to anyone without consent or a court order. So one of the key important components of this is getting patient consent. And that was part of the issue is you have to think about, am I going to be able to get consent from this patient later on, depending on what their resources are. You have to think about what access to technology that patient has, and if there's any way that you can provide access to technology so they can have services with you. Have to keep in mind how you're documenting and how you're recording and keeping information. Say key is having a secure system and also not using personal devices. This itself may be difficult depending on, as sure many of us experienced during the COVID pandemic, but having some sort of secured software or even a practice in terms of how separating personal from work, simply because you don't want to run the risk of sending something that was confidential to, say, someone who personal in your life, and that way you're not going to have one of these moments where you're going to have a violation. Keep in mind that, again, the whole point of these Part 2 regulations is to give patients an extra sense of protection, and it's simply because of the special sensitivity of substance abuse information. There's this stigma and prejudice against individuals seeking substance abuse treatment, and the goal of these regulations is to kind of prevent that and give patients extra protection so they don't have to feel that they're going to face any issues and that their information is not going to be improperly shared. So now I just described what would be the best practices of, the ideal world. If everything had been going well, all the best practices we could do for telemedicine. And mind you, a lot of this is very case specific and also, I would say, specific to what as a provider has access to. Then we had the COVID pandemic happened. And I would say a lot of these ideals kind of went out the window in terms of what we had access to. During the COVID pandemic, offices themselves were closed. There was difficulties in obtaining consent. So if you didn't already have the consent on file and the patient didn't have access to technology, and I would say simple technology like a cell phone makes it so it's going to be very difficult to get a hold of a patient. You may have had inability to access or transfer records. So for example, if you had paper records, you weren't going to get access to them unless you were physically in the office and had scanned copies. I would also for some providers, you may not have been able to access your system at your office in terms of what remote capabilities you had in terms of the software itself. And I would say there was also issues with staffing in terms of, whether it be due to financial reasons or staff not being able to work simply because of that they themselves were sick or they had childcare obligations. And at the same time as, still trying to provide these services, during COVID, you're trying to limit the potential exposure of people to each other and trying to prevent the spread of COVID. So during COVID pandemic, providers were using telemedicine to continue providing care, but there was these added challenges of being remote during a state of an emergency. So keep that in mind. It's not just working remotely in telemedicine, it was a state of emergency as well. Mind you, we are still in that state of emergency, and so as I'm going to go into in a couple of slides here, that has allowed for some of these regulations to be relaxed. I also include here, just to keep in mind, for practicing telemedicine itself, it has prescription requirements. And so during the COVID pandemic itself, that federal agency that I mentioned earlier for the substance abuse mental health, they had an exemption to the face-to-face requirement for opioid treatment programs when it came to some prescriptions. However, the DAA still had their requirements that kind of counteract that. And so this is the DAA for controlled substances, and they still required real-time audio-visual two-way interactive communications when it came time to evaluate whether or not a prescription was needed for a controlled substance. And then the dispensing practitioner had to be registered with the DEA, both in the state that they're licensed and also the dispensing state. So for example, if let's say a New York provider was trying to do a prescription for a patient that was in Connecticut, they would have to be registered with the DEA in Connecticut as well. And I wanted to put that in there just to keep in mind that there's, in terms of practicing telemedicine for substance abuse providers, there was multiple opportunities of where information was be shared. So what has changed in terms of telemedicine thanks to the COVID pandemic? So in July 2020, the HHS, they created a fact sheet trying to clarify some of the recent changes to these Part 2 regulations. And this was again in the midst of the COVID pandemic. And so they clarified that records by a non-Part 2 provider are not covered by the Part 2 regulations unless received from a Part 2 program. So if a Part 2 program is sending Part 2 records, that would still be covered. And this is, I think, very relevant when it came time to practicing telemedicine during the COVID pandemic. When a patient sends a message to a personal device of a Part 2 program employee, that was permitted, but the employee can sanitize the personal device by simply deleting the message. Prior to that, the regulations had a very long list of what the proper methods of sanitation and deleting messages, and it was, I'd say, far more complicated than simply deleting the message. And this is, as I mentioned earlier, one of the major changes is that patients can consent to disclosure to an entity without actually naming a specific and individual of that entity. Another major change was opioid treatment programs can enroll in the state prescription drug monitoring programs. And so this would allow, I would say, the share of information to see whether or not a patient was listed on one of these drug monitoring programs. It also allowed non-opioid treatment programs to inquire into the registry and get information about patients. So that was one source of change that happened to the Part 2 regulations. The CARES Act also made some changes to the Part 2 regulations. And again, these are not going to go into effect until next March of but they are adding the major exception that HIPAA also had, that allows for the use and disclosure of records for the purposes of treatment, payment, and healthcare operations with consent. So again, verbatim, it's the same exception that's in HIPAA, and they're adding it into the Part 2 regulations. This is going to be a significant change, and this will allow the flow of information from provider to provider compared to what's been happening currently. It also allows for disclosure of de-identified records to public health authorities without consent. Also, during the COVID pandemic, the Substance Abuse and Mental Health Service Administration released some guidance and clarifying again, had to follow these Part 2 regulations in the midst of COVID while practicing telemedicine. And so their statement was, we emphasize that under the medical emergency exception, providers make their own determinations whether a bona fide medical emergency exists for the purposes of providing needed treatment to patients. Now, I'll clarify that in a couple of slides here. But again, the medical emergency exception, you wouldn't need patient consent in order to disclose information. The guidance also clarified that they would allow redisclosure to medical personnel for the purposes of treating an emergency. So again, the Part 2 regulations typically forbid redisclosure. So you would need a consent for every single person or every single entity that information is going to go to. Under the medical emergency exception, that's not the case. So what is a bona fide medical emergency? As the legislative history kind of goes into, it's a situation in which an individual requires urgent clinical care to treat an immediately life-threatening condition, including but not limited to heart attack, stroke, overdoses listed, and in which it is infeasible to seek individuals' consent to release of relevant sensitive substance abuse disorder records prior to the administering and potential life-saving care. Note, it does include overdose, but it also, if you've noticed, it says urgent and immediately life-threatening. So going into that in a little more detail, any healthcare provider can make that determination about whether or not it's a medical emergency. And the commentary to the legislative history explains that it's any healthcare provider can make that determination. It also included national and major disasters as a medical emergency. So when there is a state of an emergency declared, then that is by essence a medical emergency. As the agency explicitly stated, though, this exception would not apply prior to that state of emergency declaration. So currently, we're still in the state of emergency, both in New York State and also on the federal level. However, if the state of emergency is removed and when it is removed, this exception would no longer apply. It also no longer applies when operations resume. And the state or federal agency explicitly stated that this exception would not apply prior to closing as well. So let's say this was right before everything had closed down for COVID pandemic, the exception would not apply at that time. So I've already alluded to some of this, but there are some gray areas within the regulations themselves in what's a bona fide medical emergency. So what happens prior to becoming an urgent care situation? As healthcare providers, you always want to prevent something becoming an emergency situation. You want to, I would say, treat before the patient gets to the situation of having an overdose. But unfortunately, the regulations, a bona fide medical emergency, it has to be that urgent and life-threatening situation. Again, immediate life-threatening condition. Something to keep in mind too is they're likely going to go to a hospital for an overdose and may not be going to a Part 2 facility. So these regulations, again, they don't apply to an emergency room of a hospital. And so this may not come into play for Part 2 programs because they may not be experiencing these emergency situations as much as a hospital may. And again, prior to closing or after reopening during the state of emergency, this exception does not apply. Also, this has to be the declared state of an emergency. So if a facility itself has its own personal emergency, say weather, and I'm thinking of the case of when we have hurricanes going on, or even I would say for us up north, this would be for winter snowstorms when things are closed down. Um, it, the medical emergency may not apply in that situation. Just to kind of recap here and from lessons that we've learned from being in the COVID pandemic itself, create a backup plan in terms of what you're going to do when providing telemedicine itself. Prior to COVID, some providers didn't have to think about what to do in terms of providing telemedicine services, but not only think about how you're going to provide the telemedicine services, think about how you're still going to remain compliant with these very strict Part 2 regulations. Discuss telemedicine with your patients ahead of time. Find out what services they have access to in terms of technology. Do they have a computer at home? Do they have a cell phone? Do they have access to internet? Finding out what patients actually have access to will determine, one, all right, how are you going to actually provide the telemedicine services? But also two, okay, this, say for example, a patient can only correspond via email and doesn't have the ability to do, say, FaceTime or Zoom. That's going to impact how you're going to make sure that their information does not get disclosed. Discuss telemedicine practices with your staff ahead of time, so that way your staff knows what to expect, but also so your staff can figure out with their own technology, okay, how do I make sure that this information is not getting disclosed or hacked or breached? Thinking of how to set up your home setup so you can actually provide telemedicine services and no one else can hear it. But most importantly, and I think this is probably the biggest message I'd like anyone to walk away from hearing this, is think ahead when you're obtaining consent. If you get consent with disclosing information ahead of time, it saves a lot of situations in terms of complying with these Part 2 regulations. You get consent for, I would say, covering more people than you possibly may end up disclosing to. It saves you the hassle of trying to think about, all right, is this an emergency situation? Do I need to go to court to allow the disclosure to happen? Getting consent itself is actually, I would say, the biggest way to prevent any issues from the beginning. So again, think ahead when you're having that initial conversation with patients and getting consent of who you think would possibly be a entity or a person that you're going to be disclosing information to. And this will, I would say, save a lot of headaches in the end. But also think about emergency situations. We've now had to experience, I would say, an interesting time during COVID. This has been an interesting time both for providers to practice medicine, and I'm hoping that it's given providers a chance to think about what are some situations where, okay, I wish I had patient consent ahead of time because this would have saved a headache later on. Also think a bit ahead in terms of how you're going to obtain consent from patients while you are still remote. So if you are remote, are you going to be emailing them a consent form and they're sending it back? Do you want to set up a system where they can e-fill it out? It all depends on what capabilities you have as a provider, but also what the patient's ability is as well. So keep in mind, everything is very provider specific and patient specific in terms of what you have capabilities of. And especially, I would say, especially during COVID, everyone's kind of had to come up with some creative solutions. So that is all I had in terms of information. So I think at this point, I will open it up to questions about the presentation, and I thank you all for listening to me today.
Thank you, Cassandra. That was very informative. We did have one question come in, but I think you were you provided such specific information that nobody had anything to question. But we did get a question from
I
Sarah.
also hope that means that no one's confused. I mean, I would say the Part 2 regulations themselves are very specific, and I apologize if anyone feels they're confused or overwhelmed by them, but I'm also hoping that means that all the providers out there already know about it, and you guys don't even, this is all stuff everyone already knows about.
Right. So Sarah Krassenbaum did ask, does, in quotation, prior to becoming an urgent care situation, include someone who is receiving MAT and they are at risk of missing a dose due to COVID?
I would say, fortunately, during COVID itself, because it was declared a state of emergency, allowed for the providers to make that determination themselves. So again, a healthcare provider has to make that determination if they think it actually is a medical emergency. But since we're still in that state of emergency, based on, I would say, yes, you can make that determination, you know, this is a medical emergency. But once that state of declaration goes away, it's going to be a very different situation.
Right, that will be interesting to see. So another question came in from Suzanne. My understanding is that SAMHSA has temporarily dropped the requirement to get written consent. We can receive verbal consent notated in a progress note, as long as you can get the written consent after the COVID emergency ends. So I think she's just looking for clarification. Is her understanding correct?
Yes, your understanding is very correct, that you are allowed to do verbal consent, at least during the COVID pandemic. And then with the understanding, again, as you stated, that you would try to get the written consent as soon as possible. And I think that's made it so that way providers can still keep going practicing medicine here.
All right, and then another question from Rebecca Avansky. If a Part 2 provider shares information with a non-Part 2 provider, can you clarify again, does the non-Part 2 provider have to then withhold that information if both Part 2 and non-Part 2 providers have signed release?
So if it's a Part 2 entity sending Part 2, I would say Part 2 records, so this would be substance abuse records, to a non-Part 2 program, I think it would depend on what type of non-Part 2 program it is. Simply because if they had, it's one of those, you still kind of get into a gray area when it comes to redisclosure. I would say best practices is just don't do it. Get patient consent. It makes it, I would say, for a non-gray area, especially if you are worried about, you know, do I actually have patient consent here, or am I allowed to do this? Mm-hmm. I think the non-Part 2 programs have always not been covered by the Part 2 regulations. The HHS fact sheet that they came out with was just kind of, I would say, clarifying that. And so, for example, let's say a non-Part 2 program learns that a patient is seeking substance abuse treatment or is in substance abuse treatment program, and they incorporate that records into their own records, and that information is part of their progress notes, it's part of their information in evaluating patient, it's now become their own records. If they have scanned copies, say from a substance abuse record program, that may be different. So I think it would depend on the records themselves. How did they come to play? Where are they in the record, and how are they in the record? And I hope that provides a little more clarification. I mean, I think it would be very fact specific in terms of what entities and what information is being shared.
She did say very helpful. Thank you. All right, that was the last question that came in. So Cassandra, did you have any closing thoughts for the group?
I would just say, if anyone has any questions that they think about after the fact, or even if you're, you know, thinking about want any resources, I would say please feel free to reach out. I have my contact information here, so please feel free to reach out if you have any questions or concerns. And And I know that these slides, a lot of them have, I would say, very legalese definitions on there. I know that the part of the conference, they are going to be available afterwards, so please feel free to use them as a reference if you're looking for information. And again, please feel free to reach out.
All right, thank you very much, Cassandra. That wraps up our session for today. You can join us again at 10 a.m. tomorrow. We are holding sessions daily at 10 a.m. and 2 p.m. Again, the slide deck and the recording will be on our website by October 9th. That's ahihealth.org/2020 conferences. Until tomorrow, thank you for joining us and have a wonderful day. Goodbye.